All right, folks, thanks for joining us. It's 6:57 right now. We're a couple of minutes out from beginning the webinar. Those of you who are just starting to click on and join us, thank you for joining us this evening. In a moment, I'll be introducing my esteemed panelists, and we'll get underway with the matter at hand. Good evening and welcome to the Miles Mediation Seminar, The Pandemic and Your Practice. I'm Joe Murphy, one of the mediators here at Miles Mediation and Arbitration, and I'm joined tonight with a very esteemed panel of colleagues. And I would like to go over, before I make those introductions, what we're going to do tonight. And first off, as you may know, if you've been following any of our postings on social media and other places this week, we have been asking our clients what they're going through right now as the pandemic has descended upon our lives, our personal lives, and obviously that's the primary concern, but our professional lives is what we're talking about tonight. And as a part of that, we've circulated a survey, a SurveyMonkey survey over the last week or so, where we've asked our clients to 9 questions total and asked their opinion on some topics that have been coming up recently. And we figured we wanted to start by not claiming any expertise so much as asking these questions, finding out what issues are concerning our clients, how our clients are dealing with these issues, and then offering you some thoughts that we've put together, not only from the survey, but anecdotal conversations with our clients, and as we've all been sort of to find our way through this process. But I am honored to be joined by, again, a very esteemed panel of colleagues tonight. Greg Parent joins me. Greg needs no introduction, and it would be too lengthy, and we've only got 30 minutes of prepared material, so I'll dispense with the full introduction of Greg Parent. Everyone knows Greg. Parag Shah is with us here tonight. Parag is also, in a very short period of time, I say a very short period of time, a relatively short period of time, has become one of the icons of this industry, and he brings a lot of energy and enthusiasm to ADR, as well as a lot of experience in interpersonal connections. He's a man and a master of all trades. And last and certainly not least, Winter Wheeler is with us. She's one of the newer members of our panel, but she's certainly not new to mediation, arbitration, litigation, and all of the issues that we'll be facing. So I am joined with these folks tonight, and here's the order of events. If you were with us for our 12 o'clock session, you'll hear a lot of what you've heard before. But what we will do is follow the order of the questions that we asked in our seminar, in our survey. And there were 9 questions in that survey. And we'll take them in the order that they were presented in the survey. We'll go over in a PowerPoint those questions, what our respondents put as the answers to those questions, and then we'll do some analysis. I want to make 2 commitments to you, one about the brevity and one about the length of what we can do tonight. I promise you we will cover all of our prepared materials in the first 30 minutes. So if time is a matter where you want to get back to your family by 7:30, we will have all of the prepared materials covered by 7:30. We also will be taking questions. I encourage you to use the Q&A feature in the Zoom application to ask questions at any point during the mediation. We will have a Q&A that will begin at 7:30. I will be monitoring the questions. If I feel that one of the questions that comes up is something that should probably be dealt with in the context of one of the presentations from our panelists, I'll go ahead and insert it into the mix. Otherwise, we'll be handling those at 7:30. And we will stay on the air and continue to answer all of your questions and comments as long as they keep coming. So we promise to get the material out in a concise fashion and stay here with this webinar for as long as you need us after that. So I'd like to start by covering a couple of things. First of all, if you haven't taken the survey yet, you see the first panel in here. If you're looking at the PowerPoint presentation, at the bottom is the survey link. Please go to the survey link and take the survey. This is an ongoing inquiry as far as we're concerned. We're continuing to collect data about what's important to our clients and how you're dealing with these issues. We don't see ourselves so much as the gurus of these topics and issues as curators of all of the information that we're getting. We're sort of a cross-section of the defense and plaintiff sides of the bar and other people who are involved in the mediation and ADR process. So we have this unique opportunity to bring all of the various pieces of this together and curate this information. And that's what we seek to do. So if you haven't taken the survey, please do so. And again, if we're going to be doing Q&A, and you can present your questions at any point that they occur to you. We'll probably handle them after 7:30. And in addition to questions and answers, if you just have an observation, something that you've done that you thought was effective recently in a virtual ADR situation that we haven't mentioned or covered, we would love to have your input. So please do that. Now, with no further ado, I'm going to turn to the prepared materials. And our first survey question, which you can see up here on your screen, is what do you believe is the timeline before we are able to have in-person mediations, depositions, and court appearances? And as you can see, about 70% of our respondents, around 65% actually, said that they believe this is a matter of months before we're back to some level of normalcy with these issues. And a more optimistic but smaller group of our respondents, about 35%, said it would be a matter of weeks. And we don't necessarily believe that either of those is wrong. And of course, we don't have that specific answer. Nobody does. But I think part of the issue there is when you look at the third choice that we gave, which was more than a year, nobody was checking that box. Of all the respondents we had, no one went there. And first of all, I like the optimism, but secondly, depending on what question you're asking, the answer probably is more than a year, and maybe as much as 2 years. And I'm going to just briefly tell you why we're looking at it like that. There are two issues really. The first issue, and the one I think we're thinking about most often, is what can the government keep us from doing? How long will it be before the government will allow or permit gatherings of people in groups of 10 or more? And that will be a much sooner timeline than the reverse question, which is, can the government, or how long will it be before the government can force us by compulsion to enter into a room with 11 strangers for the purpose of forming a jury? And that's, if you read the daily report today, I wrote an opinion piece and submitted it, which they were kind enough to publish today. And the timeline there is just longer, because if you think about the point in time where we would be able to, or the government would be able to tell 12 people that they have to get into a small room and remain closed in that room with another group of people, is going to be quite a while. It would have to be after a vaccine to the coronavirus is developed, tested, proven to be effective, and made universally available to everyone, really before the government could then compel people to be in a group together in a room. And it's a different question. And so the best estimates on when such a vaccine would be at that level of availability no one thinks it's inside of a year. And even if it's developed within then, to be so universally available that the government could say, okay, it's safe enough now that we can issue subpoenas, jury subpoenas, and enforce people against their will, if you will, into a room with other jurors, that's a much longer timeline. And the reason why we're looking at that is because the real question here is, and we'll get into this further with our other panelists and the other questions in our survey, is with the court system not providing the endpoint of a jury trial on the one side of the decision tree, settlements and resolutions through negotiation become the only pathway for resolution. The real question is, how long is the court pathway going to be disabled? And again, we believe it's going to be much longer than you might be thinking. And that's why we've put that out there. It's a topic of debate. We're not claiming to be right so much as we're just claiming to have thought about it. And we would like to share those thoughts with you. But I want to move on. And if I could move now to the second survey question, Q2. And Q2, 3, and 4 sort of go together. So I'm going to talk about each of those, and then I'm going to hand off to Greg Parent, who's got some thoughts to share with us on those questions. Question 2 is, have you experienced a backlog of cases that need to be moved, regardless of whether the courts are reopened in the immediate future? And as you can see, about 68% of our respondents said that they have, and obviously a smaller number say that they have not. The issue there is people are telling us right off the bat, they are having, they do have cases that need to be moved through the system. And move on now, if we can, to Q3. Given the need to still push cases forward, have you explored utilizing ADR earlier in the litigation process, including pre-suit? The question we're asking there, and you can see that the responses are about 50-50 between yes and no and a few maybes there. And Greg will go more into how we analyze that. Is ADR going to, is the timeline when you use ADR going to change as a result of what we're seeing there? And then moving on to Q4 and our respondents to that, are you open to learning how to conduct mediation virtually using technology readily available to you on your laptop, phone, or tablet? And that's the $64,000 question. And as you can see, an overwhelming number of the respondents have responded either yes or maybe, indicating a real willingness to not only utilize ADR, but utilize the virtual format for ADR. And I'm going to hand off now to Greg Parent to go into more detail of how we analyze those issues.
Joe, I'm going to go in reverse order a little bit and talk to you about Zoom. This time in February, I had no idea what Zoom was. I think we've all learned about Zoom about the same time we've been discovering the Tiger King on Netflix. Since that time, we've had the good fortune of having someone who works with CNN like Parag Shah train up every mediator at Miles Mediation and Arbitration, and that's helped us become familiar with it. What I'm finding as I reach out to the clients who have mediations already scheduled long before this coronavirus came about is a concern of whether or not it could work. And I had my doubts. Mediation is such a personal tool that we use where we get to read the room, we get to see the people, we get to watch body language. We watch attorneys size each other up and then reach across the table to shake hands once an accord is reached and we resolve the case. I was worried as to whether we could do that. We can in this virtual world. The Zoom platform allows us to park attorneys with their clients in a private room where they have privacy, where they can talk. We can also arrange rooms where attorneys get together and talk just the attorneys, even outside the room of the clients. And we get to replicate that. The only thing we can't replicate is the lunches and the cookies and the smell of the cookies mid-afternoon. As for the backlog of cases, in the short term, probably between now and summer, we're going to see that the cases that were being scheduled and in the pipeline were already here pre-coronavirus. The issue is going to be as this pipeline starts to have a lull in it, as of right now, since there aren't cars on the roadways, people aren't shopping, and premises cases aren't happening, we're going to see a change down the road. And I know Winter's going to address some of those issues later. What helped me sort of get my head around Zoom and make it more approachable and intuitive for others is when I got my parents on board. If you can get two 75-year-olds, that's how old they are, don't tell my mom. If you can get your parents and your grandparents on this thing, and if you can do social things and watch your daughter conduct a Girl Scout meeting on Zoom, then you can get your clients to do it. It's so intuitive. It's easy to use, whether you have a smartphone, a laptop, or an iPad or a tablet, and people just have a comfort level. What I've taken to doing, I think others at Miles have done this as well, is meeting with clients beforehand and conducting Zoom tutorials. When you do that with both an attorney and his client, or an attorney and the adjuster, you find that they are much more receptive to it. And by the time you get to your actual mediation, it seems like you've already had some built-in rapport. And Joe, you and I have discussed this before. When we build rapport, it usually starts at 10 o'clock. If we do a tutorial a week before or a few days before a mediation and then later reconvene, you have some built-in rapport where the folks are already trusting of you and they've seen your face. And that's important. The other thing that was quite a surprise to me, I didn't think about this with Zoom, and let's be honest, we all conduct mediations from the waist up. So you see people in shorts, you see people in sandals. They're not always business casual. We're business from the waist up. It's kind of like the mullet. But what we're finding is we get invited into people's homes, and I've been able to have frank conversations, inject some levity, and get to discuss people. When you see a grandson walk into the room, or a pet, or a kid who has a question about homeschooling homework, and the teacher, the plaintiff, isn't really good at homeschooling, and you just see a human connection where we all get to kind of smile and laugh at our new reality. The most heartening thing I'd say that I've seen with Zoom, however, is after I completed one of my earlier mediations under this new platform, and the attorney said, you know what, this worked out better than I thought, but I sure miss being in person. I miss the social nature of mediations. I miss seeing everyone, because what we take for granted and didn't realize until this happened, Joe, is that we get a lot of socialization at mediation. It used to be calendar calls at the courthouse where we'd see our friends and buddies, but on any given day, you'll see 30 to 40 of your peers and colleagues. And when you're in between caucus sessions, you get to go around and see each other and talk about other cases, resolve other cases, talk about mediations upcoming. You'll see other mediators that you're going to be working with or have worked with. That part we're still missing, but in a world where we have to socially distance ourselves and feel isolated, Zoom is a great technological Band-Aid that's really helping us sustain ourselves and move forward.
Thank you for that, Greg. I appreciate it. Only you could pull it all together with mullets and septuagenarians and dogs and kids, but I appreciate it. Well, my parents, I took your lead, and I actually worked with my parents, who assisted me in setting up some mediations with them. It was kind of fun sending my parents to their own rooms, by the way, and they would consider your parents to be spring chickens, and they too found the Zoom technology to be very intuitive and easy to work with. But moving along, our survey question number 5. If we can get that up on the screen, is if you are experiencing fewer cases in intake, and again, anecdotally, we've talked to attorneys, some who are getting more calls and some who are about the same or less, but if you're getting fewer cases, there's pressure to move the ones already in the pipeline. And as you can see from the responses, the no's are slightly more than the yeses about additional pressure that wasn't already there to settle cases in the pipeline. That tells us at a glance that maybe the pressures, that such as they were, have not altered a lot in the opinions of our clients. But Parag has some thoughts about that, and he's about to enlighten us.
There's no doubt about it that the trial hammer, having that trial deadline that you're going to be on trial Monday morning, has an impact and puts a type of pressure that can't be replicated. And with, like you talked about with the first question, Joe, we don't know when that trial deadline is going to come. But other dynamics are still in play. There are still clients that you have that are trying to get their cases settled. There are defense attorneys that have a lot of cases that are trying to move them because there are more and more cases that are still coming. Those pressures and dynamics, I think we're seeing them a lot more now because it's all happening at once. We're all at home. We're all focused intently on our cases and maybe our kids sometimes. But that's where our focus is. But the pressures are all still there. The question is, what do you do with that pressure? ADR has always been a way to relieve that pressure because it's that certainty. Right now, you need certainty more than anything because the whole world is in chaos. And part of your life may feel like you're in chaos. part of resolving cases as a mediator is we deal with these dynamics all the time. There are always pressures on both sides. And really the question about should we settle early, when in the pipeline, deals with, do you believe in the process? Because there's always, on the defense side, there's always someone holding the money and someone that wants the money. Someone that wants it for this much, someone that wants it for that much. And the process helps to bring that together. The good thing is that many of us may feel that if we can't do it in person, that process is going to be lacking. Well, through the number of weeks that we've now been doing virtual mediations at Miles, it's shocking to see how efficient, energetic, how amazing the process actually works. And the responses are staggering. It's the fear of something new that is really kind of holding people back, but the process is the same. And the process has always never been, whether you're in person or through a screen, the process has always been, are you willing to come to the table? Are you willing to listen, communicate, all those type of things? And we still have that.
Parag, I just noticed this week, an attorney on the plaintiff side advertising on social media with the catchphrase, is your case caught in quarantine? And the upshot was that their firm over the past week, while working at home as it were, had cleared over $500,000 in cases. And the upshot was, is your lawyer as good of a COVID-19 lawyer as we are? And I guess my question to you is, do you perceive a competitive advantage to both, whether it's the plaintiff or the defense side, on attorneys that can move cases, notwithstanding the current pandemic?
I'm not going to lie to you, Joe. When all this started, I kind of thought of it as a 2-week vacation that I never got. And I was okay letting things sit. Now the situation is totally different than what we thought weeks ago. This is going to be the new normal. And either you got to get on the train or you're going to be left behind, because cases are not going to stop. I was just talking to a lawyer. They were still able to file stuff in federal court. Clerks are working from home. They're still filing. Process servers are still trying to serve. Cases are coming. And if you are one of those lawyers that is just holding on to the cases because you think, I'm going to wait this out, you may get left behind, because there are going to be a new set of cases that I know some of the other panel members are going to be talking about. And you want those cases, because the best thing about the law is that it doesn't have to be the same every day. And let me tell you, the way the world is changing every day, there's going to be new cases, new types of litigation, and you want to be in there. So I don't think you want to be holding on to your cases. You want to keep that competitive edge.
All right. Thank you for that, Parag. I really appreciate that input. And that's a beautiful segue to our next question. Our Q6 was, how will the COVID-19 coronavirus pandemic impact your staffing and employment decisions? And I should say right now, the perspective we're taking on that, and if you can see from our respondents, the overwhelming majority, 70% of the respondents, said that they do not expect to be making any changes regarding staffing and employment decision making. The way we're looking at that question, and what we've been talking to our clients about, is not so much staff hire, fire, furlough, or anything like that, but really utilizing staff resources. And Parag, you just again created a beautiful segue for this, because you talked about things like filing, and clerks of court are there, and there's attorney intake, there's attorney witness interviewing, there's attorney claims filing, there's everything up to the point of resolution. And we know now the trial pathway for that is temporarily closed. The question we're trying to find out is, how can you use your employee resources, whether it's your associates, your paralegals, your legal secretaries, your other staff people working in a spread out environment as they might be right now. How can you utilize and use those folks most effectively in a post-pandemic era? And how does ADR serve a purpose in helping you get across that resolution finish line? Winter, you've got some thoughts to share with us on that.
So the survey results tell us that lawyers feel pretty confident that they can continue to litigate their cases remotely. And they believe they can do everything from intake to discovery to depositions. But the results are also showing that attorneys are apparently feeling a little bit stuck when they start thinking about the end stage, when it's time to resolve the case. And that makes perfect sense because they're just not used to closing out cases this way. So staffing in this context is mainly a discussion about how to best allocate resources in this new and evolving climate and getting people comfortable with the newly required technology when we know in advance that mediation is the end game, not trial. So instead of being hesitant or intimidated by that technology, lawyers and their firms can learn the technology and use it to their advantage at all points in the litigation process. So instead of being timid or afraid of this, look at it this way. This is a truly unique opportunity to streamline the cases and focus only on those items that you need to move forward and move in the direction of mediation and help you make the best impact on that day. So this definitely, as you said, Joe, it ties right back into what Parag spoke of previously with regard to getting cases back on track, getting the backlog moving again. But there are a lot of things that you're likely not going to do, right? Because you just don't have to. So in that same vein, you're going to be able to keep your costs lower, which of course will make your client happy. And all of that with the added bonus of saving you and your client time. And so when I have these conversations with attorneys, and I've been having this conversation a lot over the past couple of weeks, they ask me, so what do I need to do different? How do I approach my mediation differently? So, ultimately that means what resources do I really need to invest in for a Zoom mediation specifically? And my response is always, the process has changed due to the technology, but the underlying human aspect has not changed, right? So we want to focus on the things that will satisfy your client, whatever satisfaction means to them. So think about it this way. We all know parties enjoy mediation, and mediation is successful often because those parties have had their day. They've had their case heard. They've been able to tell their side of the story. And again, the technology doesn't change that aspect of human nature. So focus on what's going to give your client their day. Let them feel seen, let them be heard. So for example, you want to do things like creating more elaborate and detailed opening presentations. I always tell people, don't skip an opportunity where you have the other side's undivided attention. So for some, that's going to mean detailed day in the life videos. For others, a discussion of the law, the evidence. Do whatever you need to do to make sure your client receives closure from the process. And that's how you're going to remain successful when we don't have, as Parag called it, the trial hammer. So
thank you for those observations, Winter. You raise a lot of good points. And of course, as you see, we're now doing a webinar using the Zoom application. We're able to show you a PowerPoint at the same time that we're showing you live video of the presenter. We could have also shown you a picture right now. We could show you a prepared video while we're making the presentation. And getting to know this technology is something, once lawyers can do it, they're limited only by their imagination. And the expenses, as you've indicated, can be lower because we're just presenting things on a screen. We're not having a company make some huge graphic that needs to be brought in and put up on an easel for presentation purposes. So thank you very much for that input. We're going to move along now. And again, I'm going to state the commitment of getting all of our prepared material done by 7:30 so we can then deal with some questions that you've already got piling up here. And I appreciate that. Keep them coming. Question number 7, 8, and 9 are sort of a kind as well. And I'm going to cover each of those and do a little analysis on that. Question number 7 was, do you think there will be an increase in litigation as a result of the coronavirus? And what we're going at with that is not so much the coronavirus influencing and affecting pipeline cases that we already have, the types of cases we're already handling. We're talking more about cases that are inspired by or really influenced by the coronavirus itself, the type of litigation that can kind of arise out of a situation where people that are dealing with this issue, and you can think about the types of cases that might arise in today's in the pandemic setting. It would be obviously people delivering services, goods, perhaps to people that are victims of this, and we've seen already the system being overloaded. Perhaps people in that pipeline. We know that insurers may be faced with force majeure claims. Maybe there will be types of other litigation for insurance contracts, breach of contract claims between entities that have undertaken obligations which now cannot be fulfilled because of stresses and strains that were not anticipated. We're not going into specific cases, but the question we ask of, do our clients perceive that there will be an increase in those types of cases? By your responses to question number 7, you're telling us you do agree. And it looked, and a large percentage of our respondents, close to 70%, foresee that there would be such an increase. And if we move on to question number 8, is there an increase in litigation if there's an increase in litigation due to the coronavirus, who will be the primary targets? And when we talked about some of these entities that could be, again, these are the companies that are being affected by or having to respond to the issues and pressures created from something that many thought could not be anticipated. And our question number 9, if you look at that, what types of cases do you see being brought by individuals or companies at this time? And we've got all kinds of responses, some more colorful than others, but the point there basically being, regardless of which side of the aisle you're sitting on, coronavirus inspired and created litigation is on the way. It's coming. And this goes back to something that all of our panelists have mentioned. When we're talking about pipeline, there's a tendency, perhaps, if you think nothing's coming in, to hold on to what you've got. If you're crossing a desert and there's not a water source along the way, you're going to drink less of what you've got in your canteen. There could be a tendency, naturally, for folks to look at the current situation as intake is down, then we need to slow down the process of clearing the pipeline. The 2 responses I would have to that is, number 1 is intake will keep coming in. People will still, your potential clients on the plaintiff side who were going to go to work this week didn't. And a lot of them stayed home. They might have thought about a case or a claim that they had that they might not have brought if they had other things going on in their life. There could be people who are thinking about filing suits now over things that they might not have thought about filing suits about. That's number 1. And the second part is, there's going to be new litigation. As soon as the social restrictions have been lifted, people will get in their cars, and unfortunately, they'll start colliding with each other again. And they'll go shopping in retail stores, and some of them might fall down. And there's going to be all the things that caused people to file tort litigation and contract litigation. The human interactivity that leads to litigation will resume, and when it does, it will be resumed with a vengeance. As Greg said, when the lifeguard blows the whistle and we're back in that pool of human interactivity, everyone's going to cannonball in at one time. And so those cases are coming. And on top of that, we're going to have probably an entire class of cases that were inspired by the pandemic in so many direct and indirect ways that we probably can't even anticipate right now. That for those of us on either side of the V or in the middle, we're going to have plenty to do. So the lesson we learn and what we see from the responses to those questions are, you agree with us that there's going to be double what we had before. And the instinct, if it is to hold on to cases and not move them through the system, will put you at a competitive disadvantage to other attorneys that are moving cases and leave you unprepared to handle the onslaught of the new cases when they do come, and they will come. So that brings us to the end of our prepared materials. It's a few moments after 7:30, so I've broken my promise by about 2 minutes. What I'd like to do right now is to close the PowerPoint and to go up to putting our panelists back on the screen and deal with some questions. And we do have a few questions. The first question we've got is, do you do tutorials with all parties together or one at a time? And for that one, I'm going to defer to our tutorial champion, Greg Parent. On a day that he did a full, complex, multi-party mediation, also did 6 separate tutorials in a single day. So Greg, as the reigning champion of tutorials, will you tell us the answer to that question? And you've muted yourself.
First, I should give credit to Parag for teaching me Zoom. He's the first one to do it. And I want to give credit to our CMO, Marcy Dixon, and our CFO, Jake Miles, for really getting ahead of this. They were playing chess with this while we were kind of sitting around looking at what was going on in Italy and just watching things. They got out ahead of things. They adopted this process. They introduced us to the process. And then our own CNN expert, Parag, made us all go through boot camp and really trained us up. The way I do tutorials is I try and meet with the sides as though I were meeting with them before mediation. Instead of asking people to do extra work and send me a notebook binder or anything like that, I utilize the Zoom tutorial as a way to say, tell me about the case. What do I need to know? Talk to me about your client. Is your client going to be appearing at Zoom, or are they going to come to your office? This was early on. Now everyone's staying at home. But I use that to establish some rapport and to meet with the folks and just cover some of the things in a way that also allows them to develop rapport and trust in me. I'm still getting folks I've never meted with before. And if our first one's in a virtual setting, that's a bit of a challenge from what we're used to. It's not like seeing a familiar face with whom we've mediated over and over. So the tutorials are usually one-on-one with the plaintiff's attorney or the defense attorney in their team if they want. And I encourage all plaintiff's attorneys to bring their client on. Let them see how intuitive it can be, and let them see me and see the process so that they're not intimidated or reluctant to use it.
That's a great answer, Greg. And I know we've had some mediators who've done tutorials with elements from different upcoming cases. We have 2 or 3 people from one mediation and 2 or 3 other attorneys that are just interested in learning about the process. Well, join us at 5:30. We're going to all go on, and nothing's being shared of any specific content about a specific case. It's all just showing people, basically giving them a tour of our virtual facility and showing them how it works. So thank you for that answer, Greg. And moving along with some additional questions. This question is, how will documents be verified if required in ODR? And I'm going to broaden that question out a little bit. We do have the issue of executing a settlement agreement that everyone would normally execute at the beginning of a mediation. We have the issue of, at the conclusion of a mediation, of executing a settlement memorandum. Perhaps if there's anything else, sometimes I know the defense in mediations will bring the actual settlement documents. And we have on staff at Miles in a live mediation, we've got notaries and folks there that can notarize documents to make them official. Obviously, we have limitations on these things now because we're moving to a virtual platform. But Parag, could you go over some of the ways we're dealing with that, including the DocuSign feature and some other things?
The good news is that Zoom is not the only piece of technology that we're all going to be using. Some of us are already used to text messages, FaceTime, emails. All those are integrated within the process. So the mediation agreement, everyone at Miles, the Miles staff has done a great job converting everything to DocuSign, where you'll get a document in your email, you pull it up, and you just click sign, and that's that. In terms of the settlement memo, one of the things that I'm sure you noticed is that we were able to share the PowerPoint in the surveys results. Well, normally what we do is I draft up the settlement statement, sharing it right there with everyone. I say, hey, does this look good? Does that look good? Anything you want me to change? And then I tell them, I'm going to email this to you. If it looks good, just reply back, all good. The email correspondence confirmation is just as good in these times. And for other things like a notary or other more complex things, that just takes time. And everyone has been very creative in terms of how do we use other technology available? There is so much out there. And by putting our heads together, I haven't found a problem that we haven't been able to solve.
That's a good way to put it, Parag. And this next question, this is something that Winter's already talked about, so I'm going to toss this to her. And that is, you know, we've talked about the potential pitfalls, I guess, of virtual mediation, and we're trying to to let everyone know we've been doing this, and it's as good as live mediation. Well, the question really is are there any advantages to remote or to virtual mediation? Are there situations where it might actually be preferable or have advantages that live mediation would not have? Winter, what are your thoughts on that?
I mean, I definitely think that there are advantages to this. For one, we're saving a lot of money. That's huge, right? And we're saving a lot of time. I no longer am a litigator, but I remember it clearly. And you know, you've got the time that you invest in traveling to the mediation, prepping for the mediation, and coming up with your strategy. And previously, that strategy was based, like Parag said, on the trial hammer. And so, you know, you don't have that, but what you do have is an opportunity to change the entire narrative around mediation. Mediation is now your end game. It's where you're headed, and it's going to cost you less money. We all know that. I don't think that, you know, anyone would suggest otherwise. So what you get to do is forget about a lot of the things that you otherwise would have spent a bunch of money on. For example, those really expensive videotaped expert depositions, you may not even have to do that. You can entirely forego that exercise because in most mediations, you don't typically need to have that level of preparedness. That's something you would do after the fact, typically. You know, so to the extent that we're not doing things like that, we're going to save money in ways that we probably never thought we would be able to.
Thank you for that answer. The next question is, how do we think this situation impacts the power balance between the parties? And specifically, does it benefit plaintiffs or defendants more? And again, I think this is something that Winter had hit on briefly, and I'm gonna take a stab at this one. The whole point, and we've said this before, mediation is in many ways a great equalizer. Whereas and I'm looking at a conventional personal injury mediation where the defense room is the money room, we call it sometimes, and the plaintiff's room is the room where they're trying to get that money. The defendant, while they control absolutely what the final offer is going to be, do not control whether it's accepted. And the plaintiff, while they do not control what that number is going to be, they absolutely control whether or not they accept it. Only the plaintiff can end the litigation. Nobody else can file that dismissal and approve the settlement if the plaintiff doesn't agree to that. And the real power from the parties in a conventional mediation comes from that equality of different inputs, but inputs which essentially are both keys that have to both go into the lock to open up that door to the thing everyone wants, which is resolution. We talked before about there could be a perception that without the trial hammer, that perhaps feet are not held to the fire as much. If it's 2 years before they're starting to impanel juries and they're going to clear the backlog of criminal cases first because speedy trial demands have created a situation where there are constitutionally guaranteed rights that come before people who are involved in civil litigation. If that hammer's not there, with the babysitter gone, is everyone going to play fair? Well, that's where mediation is again, that safe place, the place where we can all come. And mediators are very good at reminding everybody of the risks and the costs and the other things that they face that should be motivating them. You know, to be in the positivity business, which we all are as mediators, we do share a lot of negativity in acquainting people with the bad side of not resolving cases. And so for people who would say, is there an inequality that's created by this pandemic situation? I don't know the answer to that. I think both sides have pressures now to find a way to get these cases across the finish line. But if there is such a perceived imbalance, nothing is going to square that up like a mediation. And you got to have people who feel there's a balance of power before they are going to voluntarily agree to anything. And providing that comfortable, safe space, a clean, well-lighted place to get things done is what we do in real mediations. It's what we're doing in virtual mediations. All right, we've got some more questions, so I want to move along and cover as many as we can. Question of does Miles give training for video mediations? I think it's been answered already. We've made it very clear. First thing we did was train ourselves. And the second thing we've done is train our clients, and we are willing to train our clients' clients and our clients' staff. The more we train, the more we learn. The way to learn something is through doing it. Let me look at some of these other questions. It says the tutorials that Greg has mentioned sound similar to a pre-caucus rather than a how-to on Zoom. Do you charge for your time on tutorial? And if so, is it by party or is it like an overall mediation charge? Greg, you charging for all of this wisdom that you're handing out on your multiple tutorials? You've muted yourself again, Greg.
I keep
The only time I've ever known you not to have anything to say.
My family wants to mute me during this pandemic.
Yeah, they wish you had that button on you permanently, I'm sure.
What we've done, we've tried not to take advantage of this time. Miles Mediation has sort of been a leader in this, and we've waived mediation admin costs throughout this time through May 1st to try and not only show people that this is a viable alternative and not just to sit around, but I've not charged anyone for any of the tutorials on how to use Zoom. What I wanted to say to answer that person's question, it can morph into the pre-caucus session. And because we are trying to all in this together, I don't have a job if people aren't mediating. So why am I going to be the person who hoards toilet paper and overcharges for the 2 plies that I do have? I'm not doing that. None of us are doing that. If you have a mediation with me or you don't, call me. You can email me. I'm happy to do it. As long as you're flexible on the time, because I'm doing a lot of these, I can work with you. Anyone on our panel will work with you. We're not here to try and do that. Now, if you do want a standard caucus where we're going to spend 45 minutes talking about a case and we don't mention the word Zoom, it's just getting caught to speed, then we'll talk about those certain things. But as far as this new normal, while we're trying to get our feet on stable ground and be sort of a safe place that Joe was talking about to level the playing field and be a beacon for normalcy, we're not trying to take advantage of that to your detriment. And that's something that we're proud to be able to offer. And we're fortunate, again, we've gotten ahead of this for some folks, and we're trying to bring everyone along and do it in a way that's helpful to everyone.
Thank you, Greg. And again, we like to hold ourselves out at Miles as industry leaders. And part of that means understanding the public service nature of what we do. If we don't help you, help your clients move these cases through the system in a time of need, then we're not what we say we are. And we're happy to provide that service to anyone and everyone, whether they have a pending mediation or not, or ever going to use us as mediators. If you just want to learn about Zoom and how Zoom mediations are done, we're there for you. Next question, I'll handle that one because it's a quick and easy one. Are the Zoom mediations being recorded? Answer is no. Zoom does permit meetings to be recorded. That feature is available on Zoom. It is completely disabled during the mediations. We would not record a virtual mediation any more than we would record a mediation that's live. We don't do that. Again, the individual participants cannot cut on the recording feature through Zoom. It's like anything else. Somebody could walk into a live mediation with a tape recorder in their pocket. We wouldn't frisk them to find that out. Somebody could take potentially a screenshot or set a tape recorder aside during a regular mediation. What I would say, first of all, is we're not recording the mediations and we're not permitting anyone else to. The second thing I would say is whatever takes place in a mediation, even if it were recorded, would never be relevant or admissible or usable outside of the mediation context. So we have to rely a little bit on good faith of the participants, but the answer in short is no. Let me move along here. Let's see. We had some compliments, people saying we're doing a great job. We appreciate that. We also accept compliments, but thank you for that. And also too, these have all had question marks on the end of them. We appreciate your questions, obviously, but if you've had any experiences and want to make an observation, we'd love to hear some of those too. This next question, I'm going to let me let Parag handle that since he was mediating today, as a matter of fact. How successful have you been in resolving cases in virtual mediations, and were the parties satisfied? And before you answer that, Parag, I'm glad the question was put that way, because we've seen people that settled cases that didn't feel like they maybe had a good time at the mediation. And we've seen impasses where people felt like they were well served by the process, because those two are linked, but they're not inseparable. So tell us about your experiences, and I'm going to put you on the spot. I know you mediated a case today. Were they happy? Did they get a settlement?
One of the things that we're doing is we're getting testimonials from people that are going through the process. So we're getting live feedback. And so far, the feedback that we've been getting is that they're very happy. I think the reason that they're happy is because this platform allows for really intimate conversations. When we're at Miles and we're able to walk around and see other people, there's a sense of camaraderie that's very warm and great and has a certain atmosphere. But in this Zoom platform, we can just be one-on-one, and they know everything is confidential. I have found that I feel that people are opening up. They're able to talk through the screen, really. The screen doesn't even really exist. I feel like I'm right there with them. And because, as you can see, look right now, the lighting is totally different, right? My lighting is totally different than Joe's and Winter's. And when I'm doing mediations, I'm seeing people, like Greg said, in their environment. And that provides a type of connectivity that I think helps the process. And that's why people are very surprised that the comments we're getting is effective, efficient, and overall amazing. And it's kind of like a shock and a wonder, because we were all kind of thrown in this without any warning, and it's working out.
Thank you for that, Parag. What I'd like to do now is we've basically reached the end of the questions, and there were some other questions I think we've answered in other parts, and I don't want to belabor anything and keep y'all here longer than you need to be. I'd like to give each of our panelists an opportunity to make a closing remark, though, and I would like to start by saying, and this has been mentioned a couple of times, there have been a couple of moments in the course of doing virtual mediations where I have absolutely felt we've reached an epiphany moment that would have probably not happened or taken place had it been a conventional mediation. And a lot of it's what Greg's talking about. When you see somebody in their personal surroundings, you sometimes see a little taste and a little flavor of who they are. And it was Teddy Roosevelt that is attributed with the quote of "Nobody really cares what you think until they know how much you care." And as mediators, we do have to build rapport and faith and trust with folks. If it's an attorney or an insurance representative we've dealt with for years, that may already be there. But with the individuals that we're seeing for the first time, very often a plaintiff in a personal injury case, any thread of information about that person and something that tells you a little bit about who they are can open up a door to a personal connection that can become very important in forming a bridge of trust with that individual. Seeing someone in the environment that they're naturally in opens that door up in a way that doesn't invade their personal privacy. But you might see one mediation I did, a lady had a floor-to-ceiling shelf filled with books that was behind her in her study. And the joke was, well, we're worried you're going to run out of things to read during the coronavirus pandemic. And we got to talking about the fact she likes to read and some other things. And what do you like to read? And other interests that she had. It is a case that involved some stressful issues. And without getting, again, any further into that, just saying it created a personal connection that I'm confident would not have been there in an in-person mediation. So that would be my one thing to share as a takeaway. Let me let Winter go next. Is there anything that you would say as a parting comment to the folks that have joined us tonight?
So I always describe myself as an extroverted extrovert with extrovert tendencies, right? So I thrive off of interacting with other people, and I get so much energy from them. And I was afraid initially, I'll admit, that I wasn't going to have that with Zoom. And I was worried that I was going to have to wait until we got back to our, our actual normal and out of this new normal. But like Parag said, it's like the camera's not there. It's like the screen's not there. I've really been able to interact and connect with people I'm mediating with. And that's been fantastic. We'll sit around, and I talk about my kids all the time, right? So I have 4 little kids, and they're at home, and I'm attempting to homeschool them. Long story. But, when I'm
I think
meeting,
a lot of people can connect with that right now.
absolutely. Right. So when I'm mediating with other people and they've got their kids running around and they're trying to, practice law and mediate and handle their clients, and at the same time deal with their kids, I really feel connected with them because, I'm running around trying to make sure my phone is on mute if I hear a kid screaming.
I think what I hear you saying is the things that could be viewed as distractions or quirks in a virtual mediation might actually be those connections that we need to make. All right, Parag and Greg, I'm going to give you each 10 seconds. I'm going to start with Parag. Take us home.
Don't worry about things being perfect. It doesn't have to be perfect. Look at this. Watch this. I can do this. And now there's more light. I can take my video off. Now I'm back. I'm gone. Learning is part of the fun. Mess around with it. Don't worry about it being perfect.
I love it. Greg, you got the final word.
The final word, I would say embrace Zoom as a tool. Don't think of it as a business tool. Think of it as your gateway to connect in this socially distant time by doing away with isolation and bringing the party to you. I've conducted 20 people for virtual happy hour that we did with Miles Mediation, where we had 20 different people, maybe 25 at one point on the screen. It looks like a fraternity composite. There's so many faces on there. I've done it with my family. I've done it with high school friends. During this time where we're all unsure, we're all scared and really uncertain about what's going on, let's be who we've always been as attorneys, the leaders of our communities, the beacons that people look to as paragons of virtue and integrity, and let's lead. Even if we're scared, let's call each other on Zoom and talk each other up, but let's project a bold face that brings people together and gives people hope in this time. And Zoom can do that. Nothing does it better than talking with your family once a week and talking with other folks on Zoom and getting that energy we need to get through the work week.
Thank you for that, Greg. I would like to thank all of my panelists who joined me tonight. I would like to thank everyone who listened and viewed in on our webinar and who provided us with questions and other things to talk about. I would say to all of you, stay safe and stay busy. Good night.